Thank you to everyone for joining this webinar about parenting arrangements and the law. This webinar is part of our Lunch in the Law series for New South Wales Law Week. And Law Week's an annual event which is all about creating greater access to justice. So it aims to talk about the law and the legal system and help people understand their rights. So this webinar is part of a community initiative between Legal Aid New South Wales, Marrickville Legal Centre, the Tenants Union of New South Wales, and public libraries with the State Library of New South Wales. If there is anyone interstate, just bear in mind that we'll be talking about services and resources based in New South Wales, although the law is a federally based law that covers Australia. So welcome anyone joining from a library group, community organisation, or YouTube, or on your desktop, or however you're joining. And welcome also to our Auslan interpreters, Angela and Sarah. So after the webinar, you'll receive a survey and we'd appreciate your feedback. And you'll also receive an email with a link to this recording of the webinar. And we also will send you a fact sheet about the best interests of children. And our webinars are always uploaded onto our Legal Aid YouTube channel. So just search for Legal Aid New South Wales on YouTube. But as I mentioned, you will receive a link to this recording. We won't actually be able to send you a copy of the PowerPoint, however. So our presenter today is Sharda. Sharda is an accredited specialist family lawyer, which means she's done extra exams and has lots of experience. And just a heads up, if you are worried about any of our content or it makes you upset or brings back some bad memories, please call 1-800-RESPECT or Lifeline. Now, I would like to acknowledge the fact that we're talking to you today from the lands of the Garigal people and the Burramatagal people of the Darug Nation. And we're meeting today for the purposes of legal education. So we also would like to acknowledge Aboriginal and Torres Strait Islander people as the first educators, storytellers and lawmakers across the lands that we're all joining from, and pay respects to the elders of this land, past and present, and also extend that respect to other Aboriginal and Torres Strait Island people joining us today. So just as a bit of a disclaimer here, we'll be providing you general information in the webinar. So it's not legal advice, don't rely on it for legal advice. And we recommend that you talk to a lawyer about your particular situation for personal legal problems. If you do type in questions, please don't expose any private or confidential information that could identify yourself, your children, if there are any community workers here, clients, children's, or anything about a family law case. And keep in mind, you should speak to a lawyer if you need advice about a legal problem that affects you or your family. And do please remember the law changes quite regularly, so you need to have up-to-date information about your situation. And we do have more information about how to see a lawyer at the end of the webinar. So we'll just cover what we're going to do today so you can see our overview is we'll look at what are parenting arrangements, how parenting arrangements are made, and what to do if things change or need to be changed, what happens if there are allegations of family violence or other safety concerns, and where to get legal help and information. So here are some questions that we're going to be sort of covering. So what are parenting arrangements? Who can give parental consent and permission for minors to attend places? And what is the difference between parental responsibility and orders for decision making? Okay, so I'm going to hand over to Sharda now to talk you through some of that.
All right, welcome everyone. Can you all hear me? Excellent. So as Jenny said, I'm a family lawyer, and I can provide you with some information here about these kind of questions. Some of these questions have come in live, some have come before, but as a family lawyer, these are questions I get asked almost every day as well. So if we can just go to the next slide. Basically, when people ask me about making parenting arrangements, they're really talking about how to decide what's going to happen with their kids' lives. So the words that we use in law are parental responsibility. That basically means decision-making powers, which apply for what happens to a child until they turn 18. So decisions like where a child should live or what school they go to, if they're going to travel overseas, if they're practicing a particular religion, if they need to get medical treatment or special permission for things. That's usually what we talk about when we say parental responsibility. The law changed recently, and I think parental responsibility is just such a mouthful of words. So we're actually using the phrase decision making a lot more now. It doesn't really cover, in a legal sense, the day-to-day things. So if a child wants to eat mashed potatoes instead of boiled potatoes, that's not something the law really gets involved in. But we're talking about major decisions that affect a child's long-term life and well-being. So automatically, this decision-making responsibility is usually shared between a child's birth parents. So both parents have that responsibility, and the way that it's actually used just depends on how the family works. So there's no one way for a parental responsibility to be shared, but generally it's shared by both parents. And the courts say that it's really encouraged. The law says it's encouraged for parents to just consult with each other where it's safe to do so when making decisions about their children's future. It's important to know that that parental responsibility can be changed. So it can be shared with other people like grandparents, extended family members, but this can only be done by a court order. Some people aren't aware that the government has the power to intervene in people's lives even whilst you're still in an intact relationship. So as Jenny mentioned, family law is a federal issue, but there's also a facet of state law. So when you talk about the care and protection jurisdiction, or what we call child welfare, if the government departments are concerned about a child's safety, they may also get involved and ask for parental responsibility to be shared to a department or secretary of the department or someone else, even whilst the parents are still together. So parental responsibility comes up in a lot of different families, whether they're in an intact relationship or separated. So if we could just have that next slide. Thank you. So what we're looking at today really is how this will change after separation. So for most people, when you're in a relationship with two parents, both making decisions about children, decisions still have to be made about who's going to do the pickup, what's going to happen on the weekend, how school sport will be arranged, things like that. And after separation, a lot of times people end up, because of cost of living or other pressures, still remaining separated but under the same roof. So the day-to-day lives of children might not actually need to change very much. If parents are changing their living arrangements and children's arrangements also need to be changed, then a lot of parents don't need to have lawyers involved or the courts. A lot of parents just reach an agreement between themselves about how they're going to continue to co-parenting after separation. And other people might need to be involved, friends or family, to help with pickups, drop-offs, decisions about certain things. But most parents just work that out for themselves. Some parents, because of cultural expectations or just needing that additional assistance, might have friends or family or community or religious members of society actually discuss with them, sit down and have discussions together to help reach an agreement. Some people want to have something formal in writing, but don't want to take it to court. And so they might consider using an independent mediator. In family law, we call it Family Dispute Resolution, FDR, but really it's just easier to say mediation. So we talk about an independent mediator who is like an umpire for the discussion that people can have, keeping it fair and helping parents write up an agreement, which is called a parenting plan, which is showing what the arrangements that people agree to are going to be. Some people use lawyers to help negotiate an agreement. We're not only just for court. They'll actually have lawyers write back and forth. And when we're talking about parenting arrangements, sometimes other things need to be sorted out too that people might need to consult a lawyer about. So they might just say to the lawyer, look, can you write a proposal about all of these things? So if there's a way to reach an agreement, that's the best way to do it. But sometimes it's not possible to reach an agreement. So if you can't work it out together, for parents, I tell clients, you might need to actually have a court make orders about the children's arrangements. Even when those orders are made, sometimes the agreement that you reach outside of court or the orders that are made inside of court might not be followed. And we are going to address what to do when that happens as well.
Okay, so here are some of the questions that we've had. Does the law say we have to follow a 50-50 split for our children? And as you can see, there's a very emphatic bubble there that says no. And what does the law say about parenting arrangements? So Shada's been talking about a more informal situation. So now we have the question, what does the law actually say?
So if we can go to the next slide, basically, when clients come to speak to me as a lawyer, I tell them knowledge is power. So for all of those joining us from libraries, just think about it. If knowledge is power, librarians hold the key to pretty much all the knowledge. So it doesn't hurt, and it often helps for people to understand what a judge would do, even if they don't plan to go anywhere near a courtroom. Because a lot of people actually have misunderstandings about what the law is or what it says should happen. And that's why I'm so pleased that we've got so many people joining us today, because really what this session is about is not teaching you how to be a lawyer, but it's more about the fact that there are a lot of people who are going through family law situations, or you might be friends or family or know someone who's going through these sorts of problems. And a lot of people are really worried about seeing a lawyer. They think lawyers are scary. I'm not very scary, but they think lawyers are scary or expensive or difficult to access. And so they don't feel like they can get legal advice directly by themselves. I want you to feel empowered to encourage people to actually find out what the law says, because a lot of people can make their own arrangements and negotiate their own agreements, but they should know what the law would do if they had to go through that legal process. And so that's why I think it's really important to know what the law actually says. Because as we saw before, there are a lot of questions coming up about where people thought that 50-50 arrangements had to be in place. The law never said that, but a lot of people misunderstood the way it was written. And so the laws actually changed last year in 2024. And they wanted to make sure that it was really clear what a judge will take into account when making decisions about a child's best interests. So what we've got here on this slide are 5 main points. This is not the wording of the law because it's actually very wordy. This is just my interpretation of it, my little summary. But I think it's really helpful to understand that if you did have to go to court and a judge did have to make a decision, this is what they'll be looking at. So first of all, what will keep a child and their carers safe from harm, family violence, abuse, or neglect? And the court will look at past and current violence orders, so AVOs or restraining orders, and they'll look at any history of harm in the relationship as well. The court will consider a child's views, and I can see a lot of questions coming through asking about how this can work and at what age. Don't worry, we will come to that. But the court will consider a child's views and also their needs, so their developmental, psychological, emotional, and cultural needs. Then also looking at the capacity of parents or other people asking for orders to actually understand those needs and meet them. And that's quite complicated in some circumstances. The court will also consider, where it's safe, the benefit to a child of having a relationship with not just their parents, but their support system. So other people who are important to them, such as grandparents and extended family members, kinship carers. And then there's another catch-all, anything else that's relevant to a child. So basically everything gets considered. But these 5 things are really important because they are specifically what a judge would look at. So it's important for you to consider those things too. Now, additionally, there's a special consideration for a child who has Aboriginal or Torres Strait Islander background, where the court should specifically consider how the orders will help that child to connect and enjoy their Aboriginal or Torres Strait Islander culture. And that's a really important consideration as well.
Okay, we've got some more questions that we've had come through. So let's just have a look at these. So how can I prove I have parental responsibility or decision-making power? And do you have to get lawyers involved? That's always a big one. And do all separated parents have to have parenting arrangements made legal? What if separation is mutual and not court sanctioned? And the difference between a parenting plan and a parenting order. So just keep those in mind as Shada goes through the next part of her presentation.
Oh dear, apologies everyone for the tech issues. But what I was saying was that when a client comes to me, I ask them why they need orders or why they need the thing that they're asking me for, because sometimes there's an easier way. We might not have to go through the whole court process if Centrelink has a form that you can fill out and just easily get done within 20 minutes rather than the whole court process to have some proof of something. So the usual reason that people need to have proof about their parenting arrangements is often because someone else is asking for that proof. So if a school says, I need to have something in writing about who's allowed to pick up this child, ask them what exactly they mean by something in writing. If the doctor says, I need proof that someone has parental responsibility before I make this referral for a specialist, or the dentist says you can't get braces on because you don't have parental responsibility to authorize this major dental treatment, you might actually need something more formal and in writing to prove that you actually have permission to give that kind of consent for a child's treatment. If we're talking about the passport office, a lot of questions are coming in about travel and things like that. International aspects of family law are very complicated, but usually when a parent is applying for a passport, both parents need to sign for that. And if one parent won't sign for that, you may need to actually get court orders, although there are a couple of other things you can do too. So if that's your situation, do get some legal advice because it can be a little bit tricky. So basically, you've just got to think about who needs the proof and then ask them what proof do they need, because a lot of people think it has to go straight to court orders, and for a lot of people, it actually doesn't. If you just need to have something in writing, so as humans, we work really well on structure and routine. So if you need to have something on the fridge that says, on these days, the kids get picked up by mom, and on these days, the kids get picked up by dad, and on these days, we've got soccer training, and on these days, we've got tutoring. You know, whatever it is that the arrangements are, that's helpful for both the adults and kids to know in advance what's going to happen. And for a lot of time, it's just something in writing that's needed. So for a lot of people, to have something that's still flexible, quite flexible is usually put in place as a parenting plan. So you can draft up a parenting plan by yourself. A lawyer can draft up one for you, but a lot of people go through mediation. So that's family dispute resolution. There are government-funded family relationship centers that can help people have mediation and write up the parenting plan afterwards for very low cost. Or depending on circumstances, they really take into account each person's financial circumstances. So for most people, the cheapest and quickest way to put something formal in writing is to have a parenting plan through mediation. It's signed, it's dated, it's proof that there was an agreement, but it's really important for you to know that it is not legally binding. So it's not legally enforceable in the form of a parenting plan. What is legally enforceable is a legal court order. So parenting orders, they're binding and there are consequences for breaking them, because you're not just breaking an order between them that's an agreement between the two of you, but you're actually disrespecting the court because the court has made these orders, and if they're not being followed, there needs to be some consequences about that. So the court that usually makes parenting orders is called the Federal Circuit and Family Court of Australia, FCFCOA. It used to have different names. There used to be something called the Federal Magistrates Court. There used to be something called the Federal Circuit Court and the Family Court. And during COVID times, the courts actually merged together. So now the Federal Circuit and Family Court of Australia is a big mouthful. We usually say the FCFCOA. If you try and read that too quickly, it makes you say something like focaccia, which is a very delicious bread. That is not the court, but just remember that the names change a lot. And when the names change, so do the forms. So if someone has gone through the family law process before, you can't just copy what they've done in the past, because a lot of things have changed. Now, when it comes to making parenting orders, there are a couple of ways to get court orders. One of the easiest ways is by consent. So for a lot of people who go through mediation, they come up with a parenting plan or an agreement, and they want to turn that into a legally binding agreement. You can actually lodge court orders to the court by agreement, by consent. So consent orders means both of you have agreed, both of you have signed the paperwork, and both of you are asking the court, please make these orders. We both believe it's safe. Every time the court looks at a parenting arrangement, it's going to apply the Section 60cc best interests principles, which is that slide I showed you before, and it's going to be on a handout that we send to you as well. So those 5 main things to look at to make sure that the arrangements are safe for everyone and in the best interests of children. So if you reach an agreement, it might be easy to document that as consent orders. And if there's no agreement, then you can ask the court for the orders you want. The court will want to hear, as a matter of fairness, from the other side as well. And after hearing both people's side of the story, the court might want other people to be involved as well, might need experts or independent children's lawyers, for example, to become involved as well, might need to have further reports prepared and so on. But ultimately, a judge can make those decisions and have final court orders made, even if there's no agreement. So as I mentioned before, lawyers are helpful. You don't have to have a lawyer involved. You absolutely don't need to get a divorce or have everything put in place in a legal way. But I do think that it's helpful to talk to a lawyer to know what your rights are and what you could do, and then you decide what you want to do after getting that advice.
Okay, now we're into this section where we're going to answer all those questions we had about views of the child and age of the child. I won't read them all out, but you can see that that's the questions that we've been getting, and Shada is going to talk about that now.
So I do a lot of presentations as part of my work as a lawyer for legal aid. I've been a lawyer for nearly 20 years. And this is a question I get asked a lot. I'm just hearing that people are finding it very difficult to hear me. Can you hear me clearly now?
Yes.
Okay. All right. If I do drop out, please do let me know. We are getting the messages where that's happened. I am so sorry about the tech issues. Now, a lot of the times, every time I make a presentation about what the parenting arrangements are for people, I get asked the question, but my child doesn't want to follow the agreement that we made. Or what age is it that a child can actually say that they want to make their own decisions? And you've allowed me to bring up one of my favorite slides. So as we go to the next slide, I know it's a little bit cheeky, and I don't mean to make light of a really serious situation, but really, age only matters if you're a cheese. When we talk about age, there is no set age in the law that says a child of this many years is going to be able to say what they want and have that followed. Because every child is different. You don't need me to tell you that. There are some really, really mature 10, 11-year-olds, and there are some completely immature 15, 16-year-olds. And there's no way that the law can actually take into account all of the variations of children and their levels of maturity and understanding. And I think it's actually really dangerous to try and make children feel like they have to make that decision, because we can sometimes put children in the position of feeling like they have to be the bad guy. They have to be the adult and manage their parents' emotional situation. Going through a separation is hard enough for the grown-ups, and it can be really, really devastating for children. And especially when they have to navigate things like siblings and step-siblings, going to a different parent's house, missing out on time with their friends, changing schools. It can be so stressful for them. And then to say that they have to make a decision and choose one parent over another, it can cause them a lot of distress. It's also not clear that what children say is always what's in their best interests, or that there's no pressure or guilting, manipulation or influence, I should say. Probably influence is a better word. Sorry, those were. That we want to make sure that children's voices are heard. It's important to listen to them, but it's not their decision what happens to them, because the adults involved are supposed to be looking out for their best interests. And if it goes to court, a judge is always going to be looking out for what's in their best interests. So it is, you can imagine, although you would say to me, Sharda, I would never put influence or pressure on my child, and they are saying this to me just because they want to. They have strong opinions, they're clever kids, and they just want to tell everyone what they think should happen. It's still going to be something where we have to be really careful about how a child's expectations are managed, because it really can put a lot of damage in place for a lot of kids. It might not happen for your child, but it might be really damaging for other children. And so we have to have these rules that apply for everyone. So informally, if you feel like your partner's not listening to what you are hearing from your child, you might want to consider whether, if your child speaks to a counselor, if it's safe and if that counselor agrees to it, whether they will share that information back with the parents or give feedback after discussing with the child what they want to say. Maybe prepare better ways for having that conversation with the adults involved. In mediation processes where parents are making that agreement in a mediation setting, there are some family relationship centers that actually have child-inclusive mediation. So that's not a child sitting at the table saying, I want on Mondays for a mom to pick me up and I want on Tuesdays for a dad to put me to bed. Not that, but their views are taken and fed back in the mediation by someone as part of that process. If we're talking about the court process, there are specialist experts who can meet with children as part of the court process and write reports which are used in the family law court setting. There are special lawyers called independent children's lawyers. And independent means really independent from everyone. So a mother and a father in a court case might have their own lawyers, and an independent children's lawyer may agree with some things that one parent says and some things the other parent says, and nothing altogether of what both parents say potentially. They're also independent from their own client. So where a child says, I want to live with this parent because I think that I have to take care of them because they cry all the time when I'm not there. Well, that might be a child's views. That might be what they express, but it might not be in their best interests to feel like they have to parent their parent. And if it's not safe for them in that place or in that situation. So we want to make sure that children's views are heard, but it can be quite complicated to make sure that it's done in a way that is not putting undue pressure on those kids as well.
Okay, so we have some questions here, Sharda, and you might just want to have a quick look at the Q&A box as well, just to revisit some things that I think you have covered a bit, but maybe we can just make that a bit clearer. But we've just got these questions here to keep in mind about when things go wrong. and, you know, from issues of communication, issues about whether you have to go back to court, and finally those situations where there is family violence and dealing with that. Thanks, Shada.
All right, so now this is something that can get a little bit complicated, but it's usually why people come to see me. Part of my job is as an emergency lawyer at the courts. Legal aid has duty lawyers who can help people when things aren't working. So remember, people don't come to tell me happy stories. They don't come to tell me when things are working. They come to tell me things have gone wrong. And so a lot of my job is actually dealing with this side of the things. What happens when stuff isn't working? So if there's an emergency situation, people usually figure out they need to see a lawyer, they need to do something urgently. But for a lot of people, they've worked out an agreement. It's been working for quite some time. Whether they've put it in writing or not, things have just been traveling on. Or they might have gone through that whole court process. It might have taken a year or 2 years or even more time. It might have cost an enormous amount of money and so much stress to get those orders in place. But they finally got it in place. And then what happens when it doesn't work? When maybe the arrangements change, so your own personal living circumstances have varied, or one person just stops following the orders or stops following the agreement, what happens then? Well, to start with, if it's an informal agreement, then you have to go through that process again to get something formal in place. If you've got orders in place, you usually would expect that everyone's going to follow those orders. And I can see quite a lot of questions here saying, what happens when a co-parent doesn't follow the orders? Or permission is supposed to be given for something, but they're not giving permission, or they're not consulting with me, or they're not following the arrangements. I'm really sorry that you're going through that, because it's a very, very stressful process. But basically, in short, orders are meant to apply until a child turns 18. And it's really hard to reopen a court case and ask for new orders. You have to show that there's been a really significant change in circumstances since the old orders were made. Something new has happened that you couldn't have imagined would happen. And the fact that the law has changed, because remember I said the law changed last year, that's not a reason to say that we should open a court case back again. It has to be a change in actual circumstances. And it also has to be in a child's best interest to make new orders in place, because kids get really stressed out when there's family law proceedings and parents fighting about their arrangements or other people involved in their lives. So the court has to look at quite a few things to allow you to come back to court, really. But if things aren't working and you've got orders in place, you don't want to be breaching orders, because there are consequences for not following orders. So if parents can work out a new arrangement, for a lot of people, when things don't work, especially if there are orders in place, the first step is to try mediation, because before you go straight to court, unless there's an emergency or a safety reason, you're supposed to try mediation. So if things are not working as soon as the arrangement is made, one of the things I often tell people is, when you're coming to make that arrangement, make sure it works. Don't sign up to an agreement that you can't follow. Don't do something in the hopes that people will change and start being different to how you know they are. Don't say that your kids will be at changeover at 8 o'clock in the morning if you know that they sleep in on a Saturday and there's no way you're going to get them out of bed to get there. Don't put yourself in a situation where you're likely to breach your own arrangements. So don't sign up to something you can't do. However, most people, once they figure out that something's not working, can maybe try mediation, reach a new agreement, come up with a new parenting plan. They might not need to do more than that, but it really depends. And it really depends on the nature of the orders and what they say. So it's probably a good idea to get some legal advice, just to make sure that whatever you're putting in place covers you. Because if the other person complains to the court that you're breaking the court orders, so that's called a contravention case. But if the court believes that you've broken the court orders, you're not only just breaking an agreement with the other person, but you're disrespecting the court's authority when the court made those orders as well. And there can be serious consequences. It can range from you missed out on a visit or some time, so you get makeup time. It could be a fine. It could be jail time in the most serious of consequences. So I really recommend that people get some advice, and we will talk at the end of the session about how you can get legal advice and assistance and information. But this is one of the areas where I really strongly recommend that people get individual advice. So there are some really specific questions that are coming up. I don't want to answer them openly here, because you can imagine, what if the other person that you're talking about is also watching this presentation? It's really important for you to get your own individual legal advice about these circumstances, because it can get really complicated. So one of the things that people have also raised is, what if my ex keeps bringing me back to mediation, keeps bringing me back to court, keeps making allegations? Well, one of the changes to the law last year was actually a new harmful proceedings order has come in, so that the courts can actually make a harmful proceedings order to kind of prevent what we call systems abuse, where one person keeps using the system as a way to control or make the other person very distressed. So if that's the kind of situation that you've been facing, and people have told you, well, there's not much you can do about it, well, the law has changed. So do come and get some legal advice if that applies to you as well.
Okay, I think we'll move on to the family violence area, because we're running out of time, and this is a really important area where lots of people have asked questions. I'm showing these questions now, and the big concern is safety. So I'll get Sharda to address that now.
So I want to talk about safety. Just safety comes first. Violence is not okay. If you feel like you're ever in danger, call the police, call 000. Don't feel like, oh, should I really do that? I feel silly. If you're in danger, call the police. If you need to get advice about something else that's happened, or you feel a bit uncomfortable about, there are a lot of really excellent support services that are available. And when you speak to lawyers, we should be hopefully linking you in with those services. And if you speak to a service and they figure out you need legal advice, they should be hopefully linking you in to get some legal advice too. So what I'd say is, if you feel like something's not safe, deal with it. Don't put yourself in an unsafe situation. And don't put yourself and your children or other people at risk. So when we talk about violence is not okay, it's actually in the law. It actually says that family violence is to be taken into account. Remember those 5 things, those 5 points that we talked about earlier, where we said safety of children and their carers is one of the really big considerations that a court has to look at. When we talk about family violence in a family law context, it doesn't just mean physical or sexual harm. It's easy to think about something that leaves a bruise as violence. Yes, that's what we understand it to be. But emotional, psychological, financial abuse, threats, including threats to hurt other people or your property, or make people think bad things about you and so on, like those sorts of threats and coercive behavior, that counts as family violence as well. So for a lot of people, it's hard to recognize that's what happened, because relationships don't usually start off bad. And when a bad thing happens, you might just write it off, and you might just say it was a one-off, and you might just feel like it's no big deal. Or it might be something that you've seen a lot of in the community or in your own family growing up, and it becomes just a normal thing, and you don't really see how much it can impact yourself, your children, and the other people around you. So it's really important to talk about these things. And I know it's hard, and I know it's private, and I know it's scary, and I know that it's really uncomfortable even to acknowledge if you might have used this yourself, or if you might have experienced it yourself. But if there are any issues about current or past or future criminal, AVO issues, family violence, actual physical violence, drug or alcohol abuse, any mental health issues or anger management issues, if people have weapons or have threatened to use weapons, if anyone's threatened to harm themselves or other people or pets, or threatened to take a child away from Australia, those are things that you really should mention when you speak to a lawyer or a support person, because they can lead to a lot of issues, but also there might be a lot that can be done to protect against that situation, but people have to know about it. We talked last time about what happens to orders when they're not being followed. One of the things I forgot to say was that the court needs to know about it. A judge doesn't call you up at home and say, hey, how are those orders going? You actually have to let the court know when there's a breach. And in the same way, if there's family violence issues, even if you don't recognize it yourself, but you feel like maybe something makes you feel a bit uncomfortable, please raise it. If there are allegations made and you know that your ex is likely to say something about these things, please raise it. Remember, everything you tell a lawyer is completely confidential. We don't share what you tell, and we're actually not mandatory reporters either, unlike pretty much everyone else who deals with children's arrangements. Lawyers are not. So if you think that there might be an issue that comes up, talk to your lawyer about it. Talk to them and ask them, what should I be doing about this? How can I make sure that this doesn't become an issue? Or how can I make sure that my children are safe? This is really, really important. If allegations are raised about children's safety, the police and the Department of Communities and Justice, so we call them DCJ, but they used to be known as FAQs or DOCs, they can investigate child safety concerns. The police can do welfare checks. There are a number of things that can be put in place right away to make sure that people are safe, but only if we know that that's something that needs to be done. So please do feel empowered if this is a situation for yourself to raise it. And if you're a friend or family member supporting someone going through family law issues, please help them feel safe and encourage them to talk about these things to professionals. Now, I really wanted to address how family violence works with family law cases, because I think this is another area where there's a lot of misunderstandings about how the law works. So the recent changes that we talked about, basically, their aim is to keep kids and adults safe. So as I said, you really should get legal advice about how family violence and safety risks could be dealt with if they're raised in your case. And I mean here both raised by someone against someone or against yourself as well. So when you go through the family law system, even if you're trying to keep it out of the court and go through mediation, mediators will screen for family violence. They ask questions in separate interviews, and they will decide whether they think mediation is appropriate or not. And they might say mediation is not appropriate because the people are not in the same location and can't get to the same place. Although for a lot of people, mediation can take place online. And so we've even done mediation. Someone asked a question about where one person is overseas. Yes, mediation can happen where one person is overseas as well. But if a mediator decides that something is not going to be safe or it's not appropriate for mediation, they give a certificate. It's called a Section 60I certificate, just because that's the section it comes under in the Act. And so a Section 60I certificate says mediation couldn't happen. The next step is court. And you can use that certificate to show the court that you tried to mediate, but it didn't work out. There's not a lot of good use in telling the court, I know my ex wouldn't agree to do mediation. It's easier to try the mediation, get your certificate, and get proof that it didn't happen, rather than tell someone you didn't do it because you know it wouldn't work, so you didn't bother trying. Now, a lot of times people are worried and think that they have to go through the mediation process, even where there's family violence or safety concerns, but that's not true. So you can still start court on an emergency basis if there is some kind of urgent reason for it. So usually the urgency is about safety issues. One of the things to know is that in family law courts, especially at the start of a case where maybe everyone hasn't had a chance to get all the evidence they need, the court can actually request records. So it can actually request records from the police, and in New South Wales, DCJ, but other states have their own welfare jurisdiction and departments. But we can request those records be fast-tracked in the court process so that a person's criminal history and the child welfare history is actually brought into court really, really quickly, so that that can be considered when making arrangements or orders at the beginning. The family law courts are federal courts, and so Commonwealth agencies might also be asked to provide that sort of information about any family violence concerns that are relating to any person that is basically connected with a child involved in a family law case as well. These things are a little bit complicated. So if this is going to be something that happens in your case or for a friend or family member that you know, tell them to really get some legal advice about this process, because the court has special screening services and pathways and judges who hear special sorts of cases, as well as really excellent men's and women's support services at the court to help parties where family violence is raised as a feature. And I have to say, this is something that happens in quite a lot of cases. Now, someone asked a question about how to actually spend time with a child where there's an AVO. And in short, to answer that question in a sort of general way, each AVO might be different. An ADVO, or an apprehended domestic violence order, we call them restraining orders sometimes, they usually have strict conditions. And so some of them have really similar conditions that are just about affecting behavior, but some of them might have conditions that prevent mediation or even being around a parent or a child. And breach of an AVO is really serious and really strict. So breaching an AVO could lead to jail time, and you really don't want to risk going wrong here. So even if the other person tells you, oh, it's fine, I'm not going to complain about it, they don't have to complain for it to still be a problem. So please, please get legal advice if you're going to make arrangements that you think might potentially put you in breach of anything, because it's so much easier to avoid it than to try and fix it when it all goes wrong. Now, when we talk about how family law arrangements are made, I know a lot of you will be saying, well, look, what are the circumstances where we can just say one parent should never see the children, or there's no contact time, or it's only, these are the conditions where supervision will be raised, or give you something really concrete about how to make sure that your arrangements can get through and what evidence you'll need for that. And I'm really sorry, but in family law, this is a terrible lawyer type answer, I know, but in family law, it really does depend on the circumstances. So each individual case is different. You can't just say that what happened to your neighbor or a friend down the road is going to be the same. And a lot of people talk about their experiences with family law, but they don't realize that the courts have changed, the processes have changed, and as I was saying, even the law has changed. So when we talk about the changes that have happened in relation to parenting, I think it's really good for me to take this opportunity and tell you that there are some more changes coming in just a couple of weeks. And these ones are really, really interesting. The courts are going to be able to make orders about family pets after separation too. Well, I mean, the courts already can, but technically pets don't count as children, they count as financial property. And so when we're looking at making those kinds of orders, it's really interesting to see the new kinds of orders that the court can make. I'm not going into it now. If you want to have another presentation about this, please do give that feedback. But I think that's really interesting to note. It's also important to note that the main part of the changes coming up is actually going to be spelling out how the court actually deals with financial cases. So at this time where cost of living crisis is pretty much affecting every part of our society, it's really important to figure out how finances are dealt with after separation. And there's been a pathway that lawyers and courts know about how to apply it, but it's never really been part of the law written down. So that's actually coming in, and it's going to take into account issues like family violence, wastage, so that's things like gambling or money that's just been taken out, and different forms of financial abuse, and even things that might have cultural implications like dowry abuse. So if your situation is, or you know someone, a friend or family member you're supporting, is I think it's really important for people to be able to get some advice if they need that, because a lot of things about children's contact centers, about subpoenaing, that is bringing into court, medical counseling notes, even some things about the divorce process, a lot is changing. So everything can change really quickly. We're all dancing on quicksand. So if you know someone, or you're supporting someone, or you're going through a family law case, please do get some advice about that. And I know you're saying, but Sharda, how? Well, watch this next slide. Okay, so just to quickly go over this, One of the places that a lot of people go to get some free family law advice at the start is Legal Aid. Now, Legal Aid has a lot of services that we can provide, from mediation to lawyers to other support persons. We do a lot of advice by telephone. We can help people at court sometimes as well. We can take on cases to represent people. But what I really wanted to do with this slide is to focus on the fact that a lot of people think if one person has seen a legal aid lawyer, they're conflicted out from getting advice from legal aid. That's not true. Legal aid has lots of different teams. I am in a specialist team, which is kept completely firewalled and separate from all the other parts of legal aid. So it is possible for us to give advice to multiple people involved in the case. We don't share that advice. The rules of lawyers say that we shouldn't be sharing information about people at all. But different parts of our services can give that information and advice to people, just to give you that clarity, the things that I was raising throughout this whole presentation about what can happen next. So we can also figure out if you might be eligible for legal aid, because the policies change all the time. And if not, where you can go to get more legal help if that's what you need, or how you can get the resources to do it yourself if that's what you need as well.
Okay, we're just going to give you some information up there on the screen about that number there for law access is Legal Aid's Inquiry Centre, and that 1300 888 529 number is the number that you ring to get onto our Inquiry Centre. That QR code there, if any of you are in a position to scan that, it will send you off to the Legal Aid website for more information, but there is the website details there. Community legal centres are an important place to get free legal advice. There's also the Find Legal Answers Toolkit, the Attorney General's website, and family relationship centres as well. They have a lot of information on their website. So we might just go on to our finishing slide and just thank everybody who's been involved with this webinar, and remind you that you're going to receive an email tomorrow with links to this webinar, a recording of this webinar, and also that fact sheet that Sharda talked about. As mentioned, we can't send you the PowerPoint slides, but you will get the recording. And don't forget that this webinar is part of a series of Lunch in the Law, and there are more webinars to come over the next few days. I just want to thank Sharda for a really great presentation. It's a really difficult area of the law to squash into 1 hour, and she's done a great job. And also thank you very much to our Auslan interpreters as well. So goodbye, everyone, and thank you again.